He drove for Uber for 3 years, 60 hours a week, every single week. Then another driver ran a red light, and Marcus Tate's life changed in an instant. When he needed help the most, the company he worked for said for words that should never be acceptable in America. They said, "You're not our employee." A jury in Atlanta saw through that lie. $5.2 million. This is a true American story. Marcus Tate was 41 years old. He was a single father of 2, a 12-year-old son named Isaiah and a 9-year-old daughter named Amara. Marcus had been raising them alone since his divorce 5 years earlier. He grew up in Atlanta, Georgia, in a neighborhood where opportunities were not easy to come by. Marcus had worked various jobs throughout his 20s: warehouse work, food delivery, construction. None of them paid well, none of them offered stability. In 2019, a friend told him about driving for Uber. The pitch was simple: be your own boss. Set your own hours, make good money. Marcus signed up within a week. He bought a used Toyota Camry, kept it immaculate, and started driving. Within 6 months, Marcus was driving 60 hours a week. He brought home between $34,000 and $40,000 a year, after expenses. It was more than he had made at any previous job. Marcus wasn't just earning money. He was providing. He paid the rent. He bought groceries. He helped Isaiah with homework after long shifts. He took Amara to soccer practice on Saturday mornings before getting back on the road. Uber marketed itself as a platform that empowered drivers. The company's own promotional materials used phrases like "be your own boss" and "drive on your schedule." Marcus believed that message. But there was a layer to that message that Marcus and millions of other drivers didn't fully understand until it was too late. On a Thursday evening in October of 2021, Marcus was driving a passenger through Midtown Atlanta. It was rush hour. The traffic was heavy but moving. At an intersection on Peachtree Street, another driver ran a red light. The impact was sudden and violent. The other car struck Marcus's Camry on the driver's side. Marcus's airbag deployed. His left arm was broken into places. 3 ribs were fractured. He suffered a concussion and a torn rotator cuff in his right shoulder. His passenger was injured as well, a broken wrist and lacerations. But Marcus took the brunt of the collision. Marcus spent 4 days in Grady Memorial Hospital. The surgery on his arm alone cost $47,000. When he was released, he was told he could not drive for a minimum of 3 months, possibly longer. 3 months without driving meant 3 months without income. Marcus called Uber's driver support line from his hospital bed. He explained what had happened. He asked about workers' compensation. He asked about medical coverage. He asked if the company would help cover any of his expenses while he recovered. The representative on the phone was polite, but the message was clear. "Mr. Tate," she said, "our records show that you are classified as an independent contractor. Independent contractors are not eligible for workers' compensation, medical benefits, or any form of company-provided assistance." Independent contractor. Marcus had driven 60 hours a week for 3 years. He had followed Uber's pricing algorithm. He had accepted rides assigned by Uber's system. He had followed Uber's rules about vehicle maintenance, driver ratings, and passenger conduct. The company had set the terms of every single interaction. And yet, the moment Marcus needed help, he was not an employee. He was not covered. He was alone. Marcus sat in his apartment, his arm in a cast, his bills mounting, and his children watching him struggle. And he felt something he had not felt in a long time: rage. He called an attorney. Marcus's attorney was a woman named Diane Foster, a civil rights and employment lawyer based in Atlanta with over 15 years of experience. When Marcus explained the situation, Foster didn't hesitate. She said, "Marcus, this isn't just about your accident. This is about how an entire industry has been built on avoiding responsibility for the people who do the work." The lawsuit was filed in Fulton County Superior Court in January of 2022. Marcus Tate versus Uber Technologies, Inc. The case attracted immediate attention. By the time it went to trial in August of 2023, 3 other former Uber drivers had joined as supporting witnesses. Uber's defense was well-funded and well-prepared. Their legal team argued that Marcus was an independent contractor by choice. They pointed to the flexibility Uber offered, the ability to choose shifts, to decline rides, to work as much or as little as he wanted. They argued that this flexibility was the defining characteristic of an independent contractor relationship. But Diane Foster dismantled that argument piece by piece. She presented evidence showing that Uber controlled virtually every aspect of Marcus's working life. The company set the fares. The company assigned the routes. The company determined the rating system that directly affected how many rides a driver could accept. The company set the rules for vehicle condition, passenger interaction, and driver conduct. The fact that Marcus could technically choose which hours to drive does not make him an independent contractor, Foster argued before the jury. By that logic, any worker who is not forced to show up at a specific time is independent. That is not what the law says, and that is not what justice looks like. Then came the testimony that changed the tone of the trial. A former Uber executive, someone who had worked at the company as corporate headquarters, took the stand. This witness testified that internal documents had acknowledged, as early as 2017, that drivers who worked full-time hours likely met the legal definition of employees under federal and state labor law. Despite this knowledge, the company had maintained the contractor classification in order to avoid paying benefits, taxes, and workers' compensation. The jury sat in stunned silence. Uber's attorneys attempted to discredit the witness. But the internal documents had been subpoenaed. They were on record. The jury had seen them. On September 11, 2023, the jury returned its verdict. We find in favor of the plaintiff on all counts: misclassification of employee, negligence, failure to provide workers' compensation. The damages were announced. Medical expenses and lost wages during recovery, $620,000. Ongoing physical and emotional harm, $1,180,000. Punitive damages against Uber Technologies, $3,400,000. Total, $5.2 million. The Uber legal team showed no outward reaction. They had expected this might go against them. Where are they now? Uber appealed the verdict. The appeal process is ongoing as of early 2025. However, during the appeal period, Uber has been required to set aside the full judgment amount. The case has become a landmark in the ongoing national debate about gig economy worker classification. Several states have since introduced legislation citing the Tate verdict as evidence that rideshare companies must provide basic protections for drivers who work full-time hours. And Marcus Tate, his arm healed. His shoulder required a second surgery, but he regained full function. He is not driving for Uber anymore today. Marcus works as a driver for a regional logistics company, one that classifies him as a full-time employee with benefits, workers' compensation, and a pension plan. He still takes Isaiah to school in the morning. He still watches Amara play soccer on Saturdays. But now, when something goes wrong, there is a safety net. Because Marcus fought to make sure there would be. Uber told Marcus Tate that he was not their employee. That when the road turned dangerous, he was on his own. A jury in Atlanta said that was not acceptable. Because in this country, if a company benefits from your labor, if they control how you work, when you work, and what you earn, then they have a responsibility to protect you. Marcus Tate reminded them of that. Justice has a pulse. Subscribe to Story Pulse Pro. New episodes every Wednesday and Saturday. And tell me in the comments, should gig economy drivers be treated as employees?